Okay, we are on the record. This is case 22396203, Maroon Property Group versus Devin or Devon Terrell Avenue and all occupants. Set for a motion to disqualify today. Appearances.
Thank you, Your Honor. Good morning, Your Honor. Sheriff Darby, 86504. The plaintiff standing in the attorney of record here.
Say your name, please.
Good morning, Your Honor. Defendant Devon Terrell Avenue, defendant pro se.
Okay, so I have been given this case for the sole purpose of just handling your motion to disqualify before a judge proceeding. Is that correct?
That's correct.
Okay. And I will allow for you to put on the record anything. Did you provide in writing a motion?
Yes, I have brief support as well with the motion.
Okay, so did you submit that to the court?
Yes, it was filed this May 26, 2023.
Okay.
Motion and brief
Just
file.
summarize.
We'll summarize. We'll go to the March 14th, which is in the brief, the March 14th, 2023 court date, where the judge, she actually went on record and made a full statement of how she's more indebted to her practice of an attorney over her elected judge seat that I have voted. I'm quite sure I voted for her. So it really spun me when I had realized what she had said on that note. So we go from there, as well as her making the statement that she was more indebted to her attorney status than her judge seat. She also has filibustering me as I was trying to rebut the plaintiff. She had filibustering me many times to keep me from being able to go on record of what we was discussing as subject matter at that point. As well, she has dismissed the counterclaim. The counterclaim is an original complaint. It has nothing to do with what the plaintiff has put forth in his fraudulent complaint. The counterclaim is for money damages, and these money damages exceed the 36th District Court. There's no reason why you should continue to argue jurisdiction when I have put in motion for jurisdiction as well to be transferred to the Third Circuit or the General Civil Division. And I'm still receiving the rebuttal of if this is not correct. This is a money damage for exceeding $25,000. It's out of the 36th District Small Claims Division, starting there. So then we can move forward into the General Division. I'm quite sure we surpass the General Division because in all honesty, this lawsuit exceeds $75,000. And this is where we come to understanding that we have not had any issues with the judge addressing these matters according to the procedure of what was filed according before the plaintiffs. There's many filings before the plaintiffs that did not get answered, that did not get called to the court. She pushed those to the side and started calling all the plaintiffs' filings. With that added in her statement of biasness is a complete fact that she has to be disqualified from the case. And if we pull the transcript, you're going to see in the transcript, she has maybe three biased statements, judicial proceeding statements here that she, in this one case.
What are those biased statements that you
I didn't hear.
What are those actual statements?
The actual statement of her saying that she's indebted to her attorney status is more than her judge seat. She had also said that my Sixth Amendment is not any good here in the 36th District Court. That's a violation of my Sixth Amendment due process. My Sixth Amendment right to represent myself in a civil matter. I have that jurisdiction right in all jurisdictions. For her to say that it was no good in 36th District, that's bias. So I moved forth on a lot of biases that she had put forth in the case on her own perception, not mine, Sean. And I'm just asking for a fair case, a fair trial. I filed for jury trial. We haven't discussed any of these. Any of these filings from the defendant has not been discussed to this very day.
You said three, there's one more statement. You said.
And the third one would be, the third one would be her unethicalness of believing that it was okay for her to make these statements and during the proceeding. It was unethical for her to do that, and it's against the judicial proceedings of judge conduct as the code of conduct. Your Honor. Code of conduct, Your Honor.
Okay, so the third one wasn't stated. It's just stating, summarizing what the two statements were that she made.
The third has been, I would qualify the third being unethical to the judicial system, Your Honor.
Okay.
Thank you, Your Honor. If I may add, I don't recall. It was a motion for our last proceeding. Oh, I apologize. Our last proceeding was supposed to take place for Mr. Adams to demand for jury trial. However, it didn't take place based on the fact that Mr. Adams did file a motion to disqualify. In terms of Judge Kennedy's conduct, I don't recall any of those statements being made, Your Honor. I'm strictly going off of Mr. Adams' motions. It's unsupported by any transcripts or any evidentiary pieces that would support or show those statements were made. In addition to that, there hasn't been any misconduct, at least to my end. There wasn't any ex parte communications with Judge Kennedy, no conversations in the chambers, no ex parte communications as to everything that's been stated.
And Judge Kennedy, she addressed the motion for disqualification?
She hasn't addressed any of my motions, Your Honor. She hadn't addressed not one of them. Maybe the day that he spoke on was going to probably be the trial for, the discussion for jury trial, but we didn't make it because the motion I had filed ahead of time before that day that even came. As well as for the plaintiff to stand here and say that there's no evidence to my disqualification when transcription has not been ordered. I think he's a little off to make that statement. He has no evidence to support what he just said when the transcripts are the concrete evidence of anything that was said on any given court hearing date. So I believe he should retract from what he just said about the transcripts and order the transcripts and then make a statement according to the transcripts.
Judge, if I may, Mr. Adams filed a motion to disqualify. I believe it was his duty to order the transcripts and substantiate the claims that he made, or he explicitly stated that Judge Kennedy made on the record.
Okay, it doesn't matter. I just wanted to have both parties speak and put their positions on the record. So I will, of course, start with the court rule that you are using in regards to your motion. Michigan Court Rule 2.003 discusses the disqualification of judge. In section B, it says a party may raise the issue of a judge's disqualification by motion, or the judge may raise it. In this case, defendant, you have raised the issue of disqualification. And based off of your motion, I believe you're raising it under section C1A, which would be the judge is biased or prejudiced or against a party attorney. Is that correct?
Correct.
Okay. Under the court rule, it requires a showing of actual bias. I'm quoting this from Kane v. Department of Corrections. Absent actual bias or prejudice, the judge will not be disqualified pursuant to Michigan Court Rule 2.003C1A. The party who challenges a judge on the basis of bias or prejudice must overcome a heavy presumption of judicial impartiality. The moving party for disqualification bears the burden of proving actual bias or prejudice. People v. Barrow, 168 Mich. App 545, 1988 case. Disqualification on the basis of bias or prejudice cannot be established merely by repeated rulings against the litigant, even if the rulings are erroneous. Further, while personal animus toward a party requires disqualification, a generalized hostility toward a class of claimants does not prevent disqualifying bias. Further, a trial judge's remarks made during trial, which are critical of or hostile to counsel, the parties or their cases ordinarily do not establish disqualifying bias. There is no rule of automatic disqualification solely because the judge has sat as a fact finder in the prior trial. That's not relevant here. Unless there are special circumstances which increase the risk of unfairness, disqualification of the trial judge as fact finder in the second trial is not required solely because the trial judge sat as a fact finder in the first trial. That is moot at this point. I don't know if you all will be having a trial. I'm just putting all the case law on the record now. Additionally, the mere filing of a party or attorney's complaint is not sufficient to require automatic disqualification. Rather, disqualification is not required until the judge is privately censured or a complaint is filed by the Judicial Tenure Commission itself. So that is the case law regarding Section A, stating that Judge Kennedy is biased or prejudiced. And you made the statements. Let's assume that what you stated is absolutely true. We don't have transcript. I'm not a word of the transcript, but wait. Let's assume that your quotes were actually factual. Based off of what she said, saying that if she was indebted to her law license over her being on the bench, and her your Sixth Amendment rights are good in 36 District Court, that still is not enough to disqualify her as the judge over your case.
But Your Honor, I would like to add.
When you disqualify a judge, it can't be based off of whether the judge and the complainant or the plaintiff or defendant are getting along, whether there have been comments made that you may not like, whether things are not going in your favor or not. Based off of what I'm hearing and what I have been briefed on, I don't have enough here to disqualify, and there's no basis, legal basis.
That's why I want to make a statement here now. We have a full.
I still want to finish.
Okay,
I will let you have that.
Thank you.
And the procedure for, in this court, because we are a court of multiple judges, I'm just placing this on the record so that you can have, I'm sure you will order the transcripts. In a court having 2 or more judges, on the request of a party, the challenged judge shall refer the motion to the chief judge, who shall decide the motion de novo. In this case, because we are a multiple judge court and I'm chief judge pro tem, chief judge is not available, so I just want to establish that why I am hearing this instead of the chief judge. So, did you have something else you want to say?
I want to make sure for the record that I have the full motion in brief here that has not been read in court, as well as.
I have it right here.
Okay, I'm just saying it has not been read in court, as well as I'm a little short of what I have put in here, but I have all the information as it comes to me. It also in the brief states that she said that she would not remove this case from either the landlord-tenant division to the general division unless I had a lawyer. She would not move the case. That's bias in itself against my Sixth Amendment as well, Your Honor, because there's no way you could make a decision to say that if I didn't have an attorney, what you would not do in a judicial tender process. She made a clear statement. That's why I think the transcripts need to be ordered before we can make a decision on this particular motion. We need to have all evidence here at the table so we can go by verbatim and understand correctly where she has made the faults in the case. To make that statement that she would not remove the case unless I had an attorney was a major blow to my Sixth Amendment violation from her. So to continue to not say that we don't have all the evidence here, we haven't really addressed all the evidence. We have a full motion, we have a full brief, we have transcripts we can order, and we can get down to what word verbatim that was said that clarifies biasness in her judgment in this case.
Your Honor, if I may recall, at the last hearing, in terms of the First Circuit Court, Judge Kennedy advised Ms. Jasmine that he would have to file a complaint. I'm sorry. Judge Kennedy advised Ms. Jasmine that he would have to file a complaint with the Third Circuit Court in quiet title action. That was the statement that was made at the last hearing in terms of prior hearing. The removal that Mr. Abney had filed was a small claims removal from small claims to general civil. This, I'm sorry, Your Honor, Judge Kennedy advised that this is not a small claims case, this is not a general division matter, this is a landlord-tenant matter, which is why it wasn't addressed based on the fact that Ms. Jasmine filed improper claims.
Your Honor, may I rebut?
No, and you're probably going to think that I'm biased at this point.
No, I'm not.
But, okay, thank you, I appreciate that. I am only making a decision on whether I believe today, based on what I have in motion in front of me and with the record, whether or not she is biased. Now, the burden is very high, it's very, very high for you to show that. And I don't believe that you've shown that today. Even if Judge Kennedy has made erroneous decisions, decisions that aren't proper when it comes to applying the law, that does not make her biased or prejudicial against you. So that would be something that you was gonna have to address in front of her through the proper legal venue. If that's an appeal or hiring an attorney or counsel to argue whatever the issues may be. It's a big file here. I don't know what all the motions are except for the motion to disqualify. But based off of what I have been told today, what I've read in the motion, she is not going to be disqualified.
I totally accept your ruling. My issue is just being able to go on record for things that are said that shouldn't be said or done. We just spoke on this issue here. You spoke of me, attorney, me having an attorney. Again, we at this level should not continue to speak on me having an attorney. That should be my own sole decision at some point. I'm just saying, I'm just trying to say I have not moved away from that conversation of someone always saying, get an attorney. That to me seems that you're not seeing the basis of the Sixth Amendment accordingly. I'm here standing in my Sixth Amendment. He just made a statement that does not have nothing to do with this motion in brief, that he needs transcripts to support what he just said about what she said May 14th. So I'm just saying in general, so I'm done at this point. So with there being no transcripts, he cannot enroll what he believes his evidence as evidence. He has to have the concrete evidence to continue to say the things he is saying here in the court today. So everything he's saying should be straightened from the record. And as I said before, we have a full motion, a full brief that contains transcripts that will pinpoint any word said that she should have been said in the court at the time that she said it. Now, for me to go further with the further paperwork of pulling the transcripts and all, I can handle that. That's not a problem. But if we standing here without all the evidence, I don't think a ruling in this particular motion should take place today. That's just on my opinion.
So I'll start with one. Even if plaintiff counsel, if all of his statements today were straight from the record, I would still have the same decision. Secondly, I am not telling you that you have to have counsel or that you should. I am telling you that you have that option. And third, it's your obligation. If you want the quotes from whatever hearings there were that you're quoting from Judge Kennedy, you have to order those transcripts.
Well, I would ask for an adjournment, Your Honor, so I can order the transcript. I can ask for an adjournment, so I can ask for the order the transcript, Your Honor.
I'm not going to adjourn this matter.
I'm just asking. I got to put it on record. I'm asking for an adjournment so I can order the
You
transcript.
submitted a motion to have a hearing.
Well, this hearing was not for me to know that I was going to need the transcripts
I
here
didn't
because.
say you needed it for me to make a decision. You're the one saying that you needed a transcript.
Okay, I'm going by the filings that I put in, so I won't continue to overload the court with filings. I can stack filings up to the ceiling, but I have to have time to have base with the judge. That's what I'm saying. So I have to have base with the judge before I can make my next decision. At this point, if we're here today and I realize I need to order the transcript, I'm asking for you to adjourn the case and allow me to order the transcript.
So what the court will allow for, if there's new information, then you're allowed to file a motion to disqualify.
I would consider new information by him making statements till he claimed that it's evidence that he has said that he has no support of. So I would claim that to be new evidence all day to the court case all day, Your Honor. Because he hasn't sustained his statements and he hasn't made them. He can't sustain
even
them.
if it was not the exact wording, there's nothing that's been said today that will make my decision change content-wise based off of Judge Kennedy's interaction with you. So if you find new information and you file a motion to disqualify, it can either be denied on its face because it's not new information, or that hearing can be held. But today, I am denying your motion to disqualify based off the motion you submitted to the court and the oral argument. Okay.
Acceptable, Your Honor. I would take the ruling and deal with it from there, but I still see that the ruling is not correct in this manner because there's not the transcripts here to support what he went against, saying that she said he had made a statement saying what the judge said. No, I have put it in the brief. He's making a statement, Your Honor. I have concrete evidence. I went to the authority given, Your Honor. I have authority given here.
In writing or in the brief, you make statements as well about what the judge said.
But I have authority given, Your Honor. He's making statements from his own perception of what he believed happened. Okay. I have authority given with filing dates. All this is evidence that has concrete base.
It's not a transcript either.
I know, but I'm saying if we order the transcript, then we can discuss what he put on record that he has no evidence.
As far as truth telling between the both of you, there's no difference. There's no transcript. So I took both of your statements and I made a decision based off of what I heard from both of you all and the content. It's not enough for bias.
I'll feel more into it. It'd be more paperwork file, It's just that it would have to go that way because now they have to see where we at this level, knowing that he has made statements for the judge as what she said. He has not 1 ounce of evidence on that side to say what she said and what she didn't
That's not a
say.
basis for a motion to disqualify.
But he shouldn't. He
The
doesn't.
motion to disqualify is with the judge.
No, I'm saying as we argue the motion.
You stated what she said.
Yeah, I'm saying
So
as we
like,
arguing
so
the motion,
I'm-
he's bringing evidence in that he has no evidence to.
If plaintiff counsel said nothing to that, what you said on the record and what your motion says is not enough to disqualify.
Right, he said.
I don't care what he
I'm
said.
saying, I'm going by March 14th, he made statements of what she exactly said.
What he said.
Okay, I'm just saying, well, I'm going by in my head that I have to
Your
follow
motion,
this.
your pleading, your request, based off of what I read and heard today from you. I am denying.
And that's what I said, I accept your
Okay.
opinion, Your Honor, and I
And
said I have to
you
deal with what I
accept it.
thought he said
I
that was
need you to accept
incorrect.
it, okay?
Okay, this is very acceptable, Your Honor, just that I have to file more paperwork, is what I was saying.
Thank you, Ms. Abby. You have a good day, sir.
So we're not done yet, we need to know what's the next court date, or we didn't fulfill this proposed report, I don't know the next.
So
court
I
date.
don't have Judge Kennedy's docket. Was there something scheduled next, or was this
There's nothing
There
scheduled
based
because
off
we're
of,
waiting on your
on
ruling.
the
Your Honor.
disqualification?
Yes, Your Honor, we're just waiting on the motion for disqualification before she
Okay.
can.
So I'm not gonna schedule for her. What I'll do is have the clerk come in the file. And I don't know, are you guys communicating via email, or do you want to go down to Judge Kennedy's for the next date? How do you want to do it?
I can put on to.
Okay, you can go down to Judge Kennedy's and get it.
I don't want to go down to Judge Kennedy. I think it'd be best that we figure the court date given out here, or you notify me by mail.
I'm not notifying you. It's not my docket. It's not my, it's not my job to do
I was
that.
finna say that. I didn't get to switch talking. I was finna say, well, notify me by mail because I'm busy as well as he is. I have a schedule to keep.
I do
today.
too. And we
So
have
that's what I'm
records
trying,
at
that's what I'm trying to get out in the record before I got all switched around.
Okay,
I'm just saying, I have a record to
So-
keep. I don't have time today to
Okay.
go to the next level for the court date.
okay.
It
So you
cannot
can
be
wait in the
here.
hallway and someone will bring your date out.
Thank you.
Outside of Judge Kennedy's work, not outside here.
Say outside, Judge Kennedy.
Yeah,
Thank you.
have a good day, sir.
Thank you, Your Honor. And staff, have a great day. Appreciate your patience.
Now calling case number 22396-203 Maroon Property Group versus all occupants of. This matter is scheduled for pretrial on a complaint to recover possession of property. Can I have your appearance, counselor?
Good afternoon, Your Honor.
Thank you, sir. Good afternoon. What is your name?
Good afternoon, Your Honor. Bonterell Avenue,
Hello, Mr. Abney.
Philly Pro Se.
Thank you, Mr. Abney. Please raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you. You can lower your hands. All right. We've been here several times. The last time we were here, there was a motion for reconsideration that had been filed by the defendant. We were waiting on Judge Sabree's decision on that. I don't have that. Has anyone received that?
I haven't received anything else as well. I know documents. Put in the transcript.
All right. Let me see what's going on. Let me check the register of actions. Okay, thank you. All right, with respect to the transcript, Mr. Abney, did you pay a deposit to the court reporter? That's necessary before she gets.
Anything from the court report, Your Honor. My understanding is for what I ordered should be $100, but my understanding as well from the court clerk when I filed that no deposit is required until the student decides the document process. I haven't seen it.
I don't know the process, but I know that I think a deposit is always required when you want to.
Your Honor, I offered to pay.
Let me finish. Let me finish. if you want a transcript, and you order one, I think you do have to pay a deposit. Now, Madam Court Reporter is here, but she's taking the record, so I don't know how much I can talk to her about it. Madam Court Clerk, what is the procedure of the court when a transcript is ordered?
Well, they have to go to the fourth floor and request the transcript. And then the information is given to the court reporter. The court reporter reaches out to the defendant. And at that time, before they can move forward.
Okay, so did you go to, my court clerk has stated that anyone who requests a transcript must go to the fourth floor to do so.
She said she's been trying to contact him. She had to get him.
Oh, okay. According to my court reporter, wait, is it the court reporter or someone from four? The reporter has been trying to reach out to you, or the reporter has been reaching out to you to try to contact you to arrange for a deposit to be paid.
Your Honor, I don't know how they reach out. I'm at 16617 Lawton, Detroit.
Do you have a telephone number? Did you provide a telephone number?
I may not be correct, but I do have the address 16617 Lawton, where I reside. The address is in the documents here on this court case. I'm quite sure someone really wanted to notify me. Something would have been in the U.S. Postal Mail. Nothing has been in the U.S.
Well, if you want a transcript, sir, if you need to communicate with the court, you need to give the court, an accurate phone number. Can you do that today, sir?
Yes, I can, Your Honor. I came in and offered to pay $100.
Who did you offer to pay?
I got it right. I offered to pay at the fourth floor at the court clerk. She said no, she's not taking the payment. So at that point, I'm on hold waiting on what they wanted to say about payment.
So just provide your phone number today so that my court reporter can be in contact with you, sir.
Yes, Your Honor. I would like to put on the record that further notice, if you have any issues calling me, please notify me at one. Data problems with my phone. I also have service problems with my phone.
So the court is not about to do all of that. We'll send a notice. What we do is if there's a hearing or, when there is a hearing, the court will mail you notice, but it's not the court reporter's responsibility to mail you, paperwork telling you that your phone number is not working. If you need to get in contact with the court, then.
The federal courts will mail you a document saying that your information is incorrect and you have a certain amount of time to contact them with correct information. So I don't know how we end up here at district court and that doesn't suffice. So that would be a different situation on another document issues, but I don't understand that. So at that point, we'll move on to the grievance that's being put on Lieutenant Miller. I have a grievance with the administrative.
That has nothing to do with this. That has nothing to do with this case.
Your Honor, I have added it to the case as Exhibit E.
It has nothing to do with the issue. No, you don't. Not in this court. You have a right. Yeah, you can file a grievance against whoever you want to, but what does it have to do with the complaint to recover possession of property?
According to a motion that I'm going to file.
But you haven't filed it yet?
I haven't filed that because I had to put in this, which is going to be Exhibit E. I'm trying to notify the court of what Exhibit E will be.
Yes, Attorney Dar. Right. Now, please don't file another motion until we get an order.
Yeah.
No, are you going to let me talk?
Yes.
Thank you. Please do not file another motion. It's very hard to keep up with the motions that you're filing when we still haven't received a decision from Judge Sabree on your motion to reconsider.
Your Honor, that's why I'm kind of like taking my time on filing this motion. I'm just notifying the court that this will be Exhibit E of the motion.
I am not going to be able to keep up with that. Just attach it to the motion when you attach it.
Any motion that I put forth before the court is a motion that I see that needs to be read as a question to the court. If I'm having an issue with security and that becomes an issue with this case and I'm adding into the case as a motion, exhibit, that's part of what my
Add it as an exhibit.
I have the right to do that, Your Honor.
Do it, but when it's not before the court. It's not before the court right now. You can put whatever exhibit you want to. You don't have to give notice ahead of time that you're gonna add an exhibit to a motion. Just file the motion and add the exhibit, okay?
Like I said, John, I was just putting on the record. See, I have a problem. Somehow I can't put what I want to put on the record according to the case that what I am defending.
It's not on the record because there's been no motion filed.
It's not on the record now, so I was letting you know, this is forthcoming. We have the right to notify the court of forthcoming. This is forthcoming, Your Honor. So I'm.
Okay, I heard you. I heard you. All right. That's it. That's it. That's it. All right. So I'm looking at the register of actions. I see, I'm looking for this decision on your motion for reconsideration. So the last thing that I see is that on July 6th, the motion to disqualify Judge Kennedy is denied pursuant to Michigan Court Rule 2.003C1A6. Disqualification requires a showing of actual bias. There was no actual bias or prejudice presented to the court through defendant's oral argument and written motions. And that was issued by Judge Sabree, as I stated, on July 6th. I do know that you filed a motion for reconsideration because I saw it with my own two eyes. But I do not see where we issued or anyone issued an order on that motion for reconsideration.
Your Honor, I want to notify the court as well. I have added to the restrictive action, the March 10th demand order removal that was never answered. I have resubmitted that on the IRO. They have noticed that they have labeled it on the IRO as a letter to the court. It is a motion to the court. It is not a letter. I don't know how the ROA got registered with a letter to the court when it's a motion. As well as I have.
What date was that filed, sir?
Have it as August 18th, 2023, as well as that that also was accompanied with both was already before the court, but when the judge ordered her orders, it was an in part order. She didn't clarify what was in part and what was not in part. So at that point, I had to reissue these onto the RA to make sure that we're going in the right direction. But they have been registered as a letter and not a motion.
Your Honor, I object to this.
Your Honor, the court, the counterclaim already had a motion pending for reconsideration. It was an in part decision from the judge. She never ruled on the counterclaim. So at that point,
she can't. Well, the only thing that was before Judge Sabree was the motion to disqualify me. She made it. Let me finish, and then you're gonna be able to talk.
That's what I'm saying. Your Honor.
No, I was talking. I was talking. No, you don't need to clarify. It was a motion to disqualify me. No, you may not. Not until I finish talking. You are going to get a chance to respond, sir.
That's all I want. That's all I'm asking.
And I give you that every time. And I told you last time, you keep interrupting. And that's how we get to where we get every time.
This is not where we should be, though, Your Honor.
Well, if you stop talking and let me talk, we won't have to go there.
Right here, Your Honor.
You filed a motion to disqualify. That was heard by Judge Sabree. She denied it. You filed a motion for reconsideration. The motion for reconsideration is on her decision on your motion to disqualify. Her motion, her order was not on, it had nothing to do with your motion for your counterclaim. She's not
Your Honor,
dealing with the counterclaim.
The motion had the counterclaim.
She's not done talking.
Let him go. Go ahead.
Your Honor. The motion had the counterclaim included. The disqualification of the judge was a disqualification in part would reinstate for the counterclaim.
That's not how it works.
That's what it's here, Mo.
Well, it was denied.
Okay, but I'm saying you're still not letting me. It denied in part. She never ordered the counterclaim back down to you. She never made an order to the counterclaim. So if it's an in part motion that was put into the court for action, and she only answers one part of the motion, the other part of the motion must be answered as well.
Not by her. It would be by me.
She didn't even recommend it back down to you, Your Honor. She did not answer to it being a in-part motion. She never answered to it.
How old is this case?
And at that point, I just put in the reference to ROA where we stand with what is still action in the courts.
We're adjourning this matter to October 17th. That's my next available day. Let me see. When we hopefully we will have the order on your motion to reconsider. Your motion for reconsideration. By then, on that day, we will be picking a trial date. Okay. I'm not sure how many motions I want you to tell me how many motions have you filed that have not been addressed by the court.
It's probably 4 motions to 5 that has not been answered.
And what are they?
We would have the counterclaim. I would want to make a list of them so I'd be correct. Now, I don't like giving things on the record that's not correct because the record we must go back to the correct.
Well, you have your file there, right?
This is a file that needs to be re-looked at, revisited to give you the right dates. So I wouldn't want to hold the courts up trying to revisit these files so we have the right date. But as well, we have maybe 2 motions from the plaintiff that has not been asked. He got a motion for cause. He has a motions to squash. He may have another motion. I have to check these things. That's why revisiting the case is very important in the proper time frame. And at this point, there's tons of motions that has not been heard. So trial seems to be the greatest way to go.
Well, we have to get a decision on your motion for reconsideration first. And I was under the impression that that was forthcoming at the last hearing. I don't know what is going on. I am going to have my clerk, Madam Clerk, did you call Judge Sabree's clerk?
I would like to have the opportunity to present my evidence. So
no, you're not presenting any evidence today because we're not having a trial today.
I said the transcripts, just bring back some transcripts. That's my evidence of whatever the motion to deny the justification of the judge is, the disqualification of the judge. I'm waiting on those transcripts so I can mark where I believe that I see what the law is that says I have been chose bias against. Now, standing here in court, I'm just speaking of a court proceeding where I have the right to stand here under 28 USC 1654, and I have 3 oppressions behind me continuing to interrupt me as I'm trying to have a great time with the community, the judge that I believe I know I have voted for you. This is not making sense for me.
You haven't voted for me, sir. But go ahead.
I will check. I always do.
I know you haven't. I know you haven't voted for me.
So I just have to check my balance.
I can tell you haven't voted for me. But go ahead. You didn't vote for me, but go ahead.
Thank you. But as I was saying, it doesn't make sense to be here in the court in a community forum. This is not criminal. This is a civil action. There's nothing criminal here today. There's nothing been criminal from this case from beginning to end. The violence from the security must stop. It has to stop. It must be ceased immediately because now it's getting out of control. Today, another issue. For what reason? They have no reason. They have none at all. So to continue to go against the constitutional rights of me having the right and the word to address myself in court and to see my accuser is getting out of control when it's constantly being infringed on by the oppressors.
I don't know who you're referring to when you say oppressor.
He's not even a part of this court case. He's
a court officer.
He's still, if I'm directing myself to you, I have not disrespected you, I have not used foul language, broken anything. He has no right to keep jumping on what I'm trying to say to you on the record.
He is here to keep order in the court. Yes, it is. And when you keep speaking over me and disrupting people, that is disorderly. And he and his colleagues are here to ensure that order is kept in the court. Okay?
How does he continue to stop what I'm about to say? If he has an issue with me outside this record, great, perfect. I'm on the record trying to defend myself in the court of law against my according to my U.S. constitutional rights. I don't want to stand here and continue to see this when I know this does not exist in the courts. It's not making sense. It's a civil action. If he was in criminal court, I can understand him clearly. If he was in civil court, he needs to understand where he's at.
Do you understand where you're at?
Yes, I do, Your Honor.
Do you understand that? Do you understand that order will preside in this court?
I understand clearly.
And do you understand, we had a long discussion the last time you were here about why the officer was so-called harassing you. And I explained to you at that time that everyone here will respect everyone. And I told you that includes you. And I told you that the reason things keep getting escalated is because when I speak, you interrupt me and you speak over me. And when Attorney Dar speaks, you interrupt him and speak over him. And you haven't done it to the level that you've done it today. You haven't done it to the level that you have in the past, but it's getting there. It's going there again.
Your Honor, I have never reached that level you're speaking on. What you said at the last hearing, the reason that this security is supposed to have some issue with me is because of what happened on Zoom. You on viral.
Sir.
These are states. This is why I speak on the record and reflect back to the record. On the record, you said my behavior was an issue on Zoom.
On Zoom and in person. And I was here. I remember every time you come here. And to who? There has an issue to who? I've had an issue with it.
There has never been an issue in person.
Yes, there has. Yes, there has, and I'm not going to argue with you anymore. I'm about to give you all an adjourn day. But you can say what you want to say. That's it. That's it.
Well, I thought you would stand for the rights.
I do.
Okay, well,
I do.
This security has to be addressed, Your Honor. This is serious here.
Sir.
Well, I'm just saying, this is serious.
What would you like the court to do?
I would like you to address this because the simple fact is this here. Some people are not going to have the combativeness to understand that they can deal with this on a legal process. They probably got here to fifth to cuss with these guys for the issue that has.
So you're making allegations that have not occurred. Nobody has been in fisticuffs, so you need to be careful what you say on the record. And again, I'm not about to argue with you, sir.
I'm speaking on mental capacity, Your Honor. Some folks don't have the mental capacity to stand for what's going on. That's all I'm saying here. So if I'm the one who has the mental capacity to take this situation and clear it up, I'll ask for the court to address it with me. Do not sweep it under the carpet.
Mr. Abney, I'm not sweeping anything under the carpet. And as I stated to you the last time you were here, the court officers will treat you with respect, but you will also treat the court officers and me and Attorney Dar and everyone else in this courtroom with respect. Respect is mutual, okay? And that's it. That's all that needs to.
You have to point out
your behavior.
My disrespect out to me, Your Honor. So
I'm not doing it. I don't have to do that. I don't have to do that, sir. I've already gone over this with you. That's your opinion.
All right, okay.
The next court date is going to be October 17th, 2023. Let me pull up my register of actions. I will let you know in one moment. Oh, wait, I won't be here October. Oh, wait, yes, I will be here October 17th. Let me give you another day. Okay, October 18th. That's Wednesday, October 18th. And hopefully we will have that order by that day. I'll schedule this matter for 9:45 a.m. That's October 18th, 2023 at 9:45 a.m. That concludes this matter. I do thank you all for your patience today. Have a good day.
Have a great weekend.
You do the same, sir.
See you on the next court date.
Have a great one.
Yeah.
Thank you. Thank you, Attorney Dar. That concludes the docket for courtroom 433 this afternoon. Thank you to my court staff and thank you to all of the attorneys.